I'm Scott Reese, ACBR Education Chairman, and with me is our Vice Chair, Jim Caswell. Since we will not be able to gather together for several months and host some terrific education seminars, we want to find other ways to reach out to our members. Also, we realize that we are experiencing rapid changes in our industry, and we want to do all we can to bring you the most relevant, up-to-date information. Therefore, we are going to present weekly video snacks for our members until we can get back to our regularly scheduled monthly seminars. We will be putting these together on a regular basis and plan on hosting at least 1 to 2 times each week, depending on availability of our guest speakers. Just like everyone else, we'll be doing these from our homes, so please excuse any interruptions.
Thank you, Scott. And this is Jim Caswell. We'd like to say first and foremost that none of this would be possible without the support of our annual corporate sponsors and our annual education sponsors. They have been longtime supporters of the ACBR, and let's be sure the next time you have a video chat or you see one of our sponsors, you thank them for their support. We hope you enjoy the videos. We hope that you stay safe out there.
So on behalf of the Education Committee and our commercial board, we are excited to bring you these important and timely conversations, and we hope you enjoy our snacks.
Greetings to everybody, and thank you, Phil Skinner and Abe Schear, for joining us. Phil and Abe from Arnall and Gregory have been kind enough to provide some of their valuable time in this time of crisis to assist us at the board with many questions that many of our clients are asking in relation to our lease agreements. And with that said, Phil, I think you want to say a few brief words as we dive into a very hot and happening topic. And I also want to take a moment to point out that this was recorded on April 8th. And the reason I say that is everything that's happening is changing and is so fluid right now that what this conversation contains may be irrelevant in 2 or 3 weeks in portion or in part. And so I do share with the audience, April 8th, 2020 is when this discussion occurred. With that said, Phil?
Yeah, thanks, Greg. That's a very good point. I want to start by thanking the Board of Realtors and thanking you, Greg, for this opportunity for me and Abe to join you on this chat. We hope everyone finds it informative, but even more importantly, we want to say to all of our friends in the Atlanta Commercial Board of Realtors community that we hope you're all well. We hope your families are healthy. We hope you're staying isolated, and we hope you're getting through this very difficult time, as best you can under these circumstances. Abe, I don't know if you want to add anything to that.
No, I certainly agree. I mean, I think that we are a community, and it's really we've always been really happy to work with this organization because we know so many of y'all and we're friends with so many of y'all, and we want to all get through this healthy, and we want to get to the other side of this, and we know that the relationships that we all have invested in the years will really help us do that.
Great.
I guess I'd also say more to that point, Abe, that we miss everybody. We're so used to seeing each other in this community, and now in this period of isolation, it's made me realize, that the Atlanta Commercial Board of Realtors is a great group of people, and we just miss the opportunities to spend time with each other, and I'm looking forward to that coming again soon.
Great. Well, thank you, gentlemen. With that, I think we'll go ahead and dive into it.
Well, Abe, I think that as our listeners might be able to already tell, you focus more on retail than office and industrial, and I tend to focus on office and industrial, perhaps like Greg does as well. I think landlords and tenants come in all varieties, all shapes and sizes, and they have very different situations depending on who they are. A lot of factors go into that, but for any of these decisions, the starting point is inside of a lease, I think, to figure out what as a tenant you want to ask for, what as a landlord you're willing to try to give tenants some relief on. I think landlords might have a different lens to look through as well. If a particular tenant has been a difficult tenant that's always chronically late with rent and is a problem tenant, they might be less sympathetic to that tenant than they would to a good tenant who's who's not been a problem and is always paying his rent on time. So there are many factors that can go into how a party might analyze this. One thing you alluded to is, we're just at the beginning of this whole pandemic and what it means to leasing. I don't know if our answers today or our thoughts today are going to be the same ones we would give 3 weeks today or 6 weeks from today. So I think we all need to remember this is a pretty fluid and novel situation that we're all of us, landlords, tenants, lawyers, brokers, we're all trying to react to. I'm sure, Greg, you're already experiencing that as well.
Yeah, Phil, I think the other category to add, landlords, tenants, brokers, and you alluded to it earlier when we had a conversation, but lenders and how do they play into this and how do they become part of this?
Yeah, so that's a great point, Greg. And that, for landlords, they don't necessarily own this decision by themselves. The ability to grant a rent deferral ends up being a lease modification, and in most commercial mortgages, if not all, a landlord is not allowed to modify a lease to reduce rent or shorten term without the consent of the lender. So you got a third party outside the lease, a little bit outside the lease that you've got to talk to. Many landlords have got equity partners that in their JV documentation may have consent rights to this kind of modification as well. So it's just not simply always a landlord and tenant decision standing alone. And there are other parties and thousands of tenants and leases and landlords thinking about this. So,
right.
Priority becomes an issue. I mean, as a landlord, I've dealt with a number of office landlords. The first party that they helped was their cafe operator. If you're running a cafe at the bottom of an office building, and 90% of your business is driven by tenants, you're dead in the water, even if you're allowed to technically be open. So many landlords have granted rent deferral, not rent forgiveness, rent deferral to those tenants. And as Abe mentioned, you might spread the rent over the calendar year 2021, or you might add it through the rest of the term, or you may add term to the term in consideration of that deferral. So there's a lot of ways to skin the cat. And I think each tenant may have different needs as well.
Yeah,
Abe, what do you think?
Well, Greg, let me add one other point, and this would go for any kind of lease. One of the tragedies that we could have here is that if we try to go back to business with the exact same lease, thinking the exact same way, I think that we're going to find it's certainly true in the retail, but it's also true in other segments of our industry, that some of the clauses in the lease just simply are not going to work. We're finding that the lease does not address certain things. And on the retail side, it's an easy example. On the retail side, you might decide that you're going to have more of a deferral, but the tenant is going to have to give up some rights that it has. It may get a deferral of rent in return for a modification of a co-tenancy clause or a relocation clause or a different kind of clause. And I think that each landlord needs to go back at the end of this, regardless of category, office, industrial, retail, it really doesn't matter, and decide whether or not its lease really, really works. We tend to, as an industry, love our leases without change for the last, 10 or 20 years. I think that the number of clients that ask us to rewrite or really modify and update their lease is tragically low given the vast change of our industry.
Probably 911 was the last time, right?
I'm sorry?
Probably 911 was the last time.
Maybe so. And the industry has not only changed a lot just internally in the last 15 or 20 years, but this is going to be a wholesale change, and we're not going to go back to what was normal. We will go back to a new normal. And landlords that do not update their insurance sections and update their force majeure sections and update other provisions of the lease, perhaps the rules and regulations and other things like that, rethink different clauses that they normally agree to, I think we'll really be at will be doing, will be failing to do that at their own peril. And I think
well, obviously,
really
Abe, I think that one of the clauses you just mentioned that everyone is going to be relooking at is the force majeure.
Right.
And that's, you know, in the last 3 weeks, I can't even tell you how many leases we've been asked to look at to see what the force majeure provision says. And lots of tenants are thinking that it might forgive or excuse their failure to timely pay rent. And unfortunately, I think they're going to realize when they scrutinize their lease that most leases do not have force majeure forgive monetary obligations of the tenant. Some landlord lease forms even only run in favor of the landlord in the force majeure clause. They don't even say both parties are excused from an obligation. A lot do excuse both parties, but they rarely excuse the obligation to pay rent. So
if you have to scan a stack of leases for the words force majeure, you'll also learn that some landlords don't use those words at all. They use inability to perform or other things. But look, our clients are calling on us and looking for any way they can possibly save. And what we're telling them from a directional standpoint is if you're in real financial hurt, and I think Abe is seeing this on the retail front, particularly restaurants and that type where it's clear and obvious they're in financial hurt, the landlord wants to see those financials. The landlord wants to know, really are you in harm? And then, then I think the conversation opens with the concept of what you described, Abe. But on the office front, Phil, what happens is many of our clients are hearing this and they're trying to equate that applies to everybody. Maybe share a little bit about that. And then really, I'd like you to expand on force majeure, because what I'm finding is once my clients are starting to understand that if they're not in real need, by definition, really those sectors that I mentioned in the opening call, whether it be the hospitality or the restaurant or hotel or travel, it's difficult for them to basically open the Komodo and show exactly where they are and really are they going to go out of business next week if they have to pay their rent. So from that, the next step and the next stage they're asking is, let's look at the force majeure clause, usually driven by a general counsel or a real estate lead. And that jumps right into what you said. Now, whether it's to pay rent, it certainly is not applicable, but in this current environment, force majeure has many other meanings in many other areas. And I'd love for you to expand on that as it relates to, say, construction, and some of the other categories within the lease, because I think it is something that will be invoked as we go through this process.
So both Abe and I can respond to this. Why don't you go ahead first, Abe?
Well, I was going to say, I think we'll have a more comprehensive answer to this, but I think that again, one needs to look at what you said, Greg, needs to look at the force majeure and make sure that it applies to all of the things that it wants. I think that one of the issues that we are going to have and we're going to struggle with in the months to come is how force majeure impacts construction. I mean, everybody's got construction timelines and you've got dates and you've got penalties. And there's going to be a very good question on a lot of leases as to whether or not the leases were crisp enough and precise enough to deal with force majeure in the context of delays that are certainly going to occur, and whether or not the penalties will in fact be applicable or not. So, I mean, I think that one is going to need to go back and figure out what do they have drafted in the lease. And I think that this is going to be a time people are going to go back and reread their leases and make sure that they know exactly what they have. And also when we go back to the deferrals or abatements or whatever it is, whatever we're going to talk about the rent, that we make certain that we know how the force majeure is going to impact other things so that we can clean that up at the exact same time.
So one of the force majeure construction issues we've looked at recently is that although in most cases the landlord is responsible for the construction and delivery, and that triggers the commencement date, in some cases with bigger tenants and with experienced tenants with multiple sites, the tenant has taken on the construction obligation. And usually that language in that lease is, it says after X days, after 185 days, the commencement date will begin. Because the parties on the front end have said, we think it's going to take 150 days, give me a little grace on that, and they set 180 days as the construction period. Well, does that period of time get extended due to force majeure? And if it does that postpone the commencement date? So
Sure.
as a tenant, you're not asking to forgive rent. You're asking to delay the commencement of the rent. And it's very lease and language specific on, the success you'll have as a tenant. I think the landlord's going to say no way. But I think what we don't know is how courts will now interpret these force majeure clauses in the face of a global pandemic that's affecting the whole world. We don't know.
Sure.
There may be some case law from 1919 and 1920 about this. I can promise you I haven't read it yet. And I'm sure it's very exciting reading. But, I don't know what the court is going to say about that. And, I don't know that I can handicap who's got the better argument on that right now. But as a tenant, I would make the argument, if I'm responsible for construction and I can demonstrate delays in construction due to the effects of the global pandemic, I would assert that. I'm not trying to forgive the rent. I'm not trying to not pay rent. I'm just postponing the commencement date.
Yeah, whether it be an order from a governor to construction's not allowed, like in many states in the country right now, or whether it be the fact that the furniture manufacturer has suspended operations, and to get the C of O, they've got to have the modular furniture in, and they can't get it because there is no furniture because it hasn't been built.
Yeah, it can even be the timing of governmental inspections. It might take you 2 more weeks to get the guy from the city to come out and do an inspection. That's not the tenant's fault. It's not the landlord's fault. It just is something that might be a consequence of the situation we're all in. Abe, you were going to say something. I'm sorry.
Well, I actually was going to say exactly what you just said, Phil, which I think is correct. That you can't necessarily get inspectors or the government to get out to do things that it needs to do. But the other thing that I would remind everybody, and I don't pretend for a second that the listeners of this don't know everything already. It's more of a matter of being reminded, is that you're really seeing the best of the people that are out there talking with one another. So if you're a landlord, if you're a tenant and you've got an issue, the best thing you can do is have a relationship with that landlord right now, so that the landlord and you are on as close to the same page as you can be. Phil said earlier, and quite rightly, and I've listened to a lot of landlords talk about this, this is an opportunity, and landlords will use this to treat different tenants differently based upon who they need the most and who they don't need the most. But tenants that want to be treated well and landlords that want to have a relationship with those key tenants need to communicate. It is remarkable how much my phone is ringing and how often I'm on the phone today compared to a month ago. Good conversations. Hi, how are you? What's going on? What are we going to do down the road? Will do a world of good in terms of a relationship that otherwise would simply be done by, we've defaulted to an awful lot of emails. So I think some of these old time skills that so many people that are involved in this industry, and particularly in Atlanta, have will be valuable. But we need to get back a little bit more into the people business so that there is a warmth and a friendship between the landlord and the tenant.
Abe, you nailed it. It's a people business, a relationship business, and we're in the middle of a crisis like we've never, ever seen. And we all want to come out of this, and I tell this to my clients and to the landlords and everybody, we all want to come out of this and still have a business relationship when it's done.
That's right.
I want to comment on sort of the extremes of the landlord positions that I've seen so far. So at one end of the extreme, I have seen landlords that are simply immediately saying to all of their tenants, or even sent out a preemptive letter that said, you need to look to governmental relief programs and or to your business interruption insurance for any claims you want to make to try to get rent relief of some kind. And, that's an answer that was sent out even before April 1st in the extreme cases. We have a number of landlords who said, I'm going to wait and see who pays and who doesn't pay on April 1st. I mean, now that it's April 8th, I've got a snapshot of the real position various tenants have taken, even if I haven't heard from them. At the other extreme, I know of at least one landlord who did not have a mortgage on his building, and they basically said to all of their tenants, we will grant you 3 months rent relief. Don't need to look at your financials. We know everybody's in this together, and we're going to give everybody 3 months. We're going to extend the term by 3 months. We're going to pay it back over a period of time. But, you know, if you think you need this, we will give it to you. Now, that is a landlord that's made the decision that they're investing in their tenants and they're betting on the long term. A landlord who has taken the other extreme position may change their mind, and I think that'll be a lesson they learn over the next 2 to 4 to 6 weeks. This is a fast-changing situation. So the decision a landlord made to send out an early letter can change by May 1. I mean, so I wouldn't take that as the absolute answer if I was the tenant of that landlord. I would get the dialogue going, like Abe mentioned and like you said, to try to create an opportunity to get some relief down the road.
And that might need to be a try conversation and bring the lender involved, depending on the size of the tenant too. So
yeah,
I think that's right. Let me say, Greg, and Phil mentioned this, but let me highlight it a little bit more. That a lot of the letters that are going out now, and I think that they're pretty well done, show that if the landlord is going to defer rent, the landlord also expects the tenant to apply for benefits pursuant to the governmental applications in the CARES Act. Now, whether or not they'll be able to get any of that rent that might be received by the tenant back in lieu of the deferral, I don't know. But the landlords are doing that, I think, to sort of preserve the rights to make certain that the tenant doesn't have isn't having rent deferred or even forgiven, and then getting it paid back by the government and not using it for the benefit of the landlord. So I think that there's no harm in doing that. Contractually, it's a perfectly fine obligation to request that the tenant undertake.
Yeah, I think I've seen a couple of varieties of that, Abe, and it's a good point. And some landlords want to write in an amendment or a modification that they're going to get copies of everything that's filed. They get to participate in the process, if you will. I'm not sure all landlords are set up to do that. I mean, you'd have to have someone looking at every application. I think the approach that Abe just mentioned is, we want you to apply, you've got to agree to do it, you've got to try to get any of the benefits you can, and to the extent that you get rent-related benefits, those have to come back to the landlord. Sure. And they're not going to be in the oversight business, but they're going to, they will be in a position to find out if the tenant did get that relief and failed to get it back to the landlord. And that would be a breach of trust, I think, a breach of good faith in that relationship, if not a breach of the contract that we write for a tenant to get that benefit and not return it to the landlord to repay the deferred rent. So, well,
conversely, if I might, on the restaurant business side, many of us have restaurant clients and restaurant work. We really want the tenant to undertake an application, because the application would indicate that they also are probably filing for benefits that ultimately would only inure to them if they stay in business, because they're applying for benefits that would be for their employees, and that would be very important.
Yeah, so let's just, I know, Greg, we're going to mention something more about the CARES Act later on, and we're not going to get into that in detail today, but sure. I do want to at least anecdotally mention to you and mention to our listeners that we know of one major bank in the Atlanta community that as of Monday morning had received 110,000 loan applications,
right?
All of which were from customers. So if you want to make an application under the CARES Act, you better make it as soon as possible if you haven't already done it. You're going to be at the end of a long line if you keep waiting to do it, and that fund will run out of money, because there are millions of applications being made across the United States. And,
sure.
I know that I saw in the news there may be another round another $250 billion round of funding for these loans. I hope that goes through because I think it's going to be needed. But if you're thinking about doing an application, you better get it done because you're going to already be at the end of a long line.
Absolutely. So we talked about different sections of the lease document. We alluded to default. We've really focused on the reality, which is look, it's a relationship business, and its communication is just so important at this point between the tenant, the landlord, and the lender as well. In absence of all of that, and we go in a path that I don't think any of us desire, but it takes us to the courts. In a disagreement between each party. What do you both anticipate? Because I'm seeing across the country moratoriums on evictions and moratoriums in terms of court closures, et cetera, the backlog, the log jam, almost, another reason why we need to work these things out with our real estate attorneys and brokers and getting these things resolved before it gets litigious. But curious what your take is on that.
Go ahead, Abe.
My take is that you're going to have two different piles, Greg. I mean, on the one pile, you're going to have most people that realize that if they go to the courts, by the time they get through the courts, the result, a bad result, probably already will have occurred. So there will be people which makes me believe that most people will not go to the courts. The landlord and the tenants and the lenders will work this out because they really do have a mutuality of interests. Mm-hmm. On the other hand, I think the easiest guess is that the people will generally, and this is terrible, but the people will generally have more fodder for why they don't like lawyers 2 years from now or 3 years from now. There will be an enormous amount of litigation about bad landlords, bad tenants, bad contractors, why did people contract the coronavirus, who got who sick, who did this, who did that. The courts will be full of this, and my guess is, we've not read much about this, but I put $100 on this one. I think that at some point there will be legislation that relieves an unlimited obligation on the part of an operator in particular, who was deemed somewhat of a let's say let's go to a grocery store or something. Somebody gets sued in a grocery store for this or that. I think there will be some relief so that you don't find the grocery stores and the Walmarts and everybody else like that that are sued for unlimited numbers of millions of dollars. And I think that there'll be an overriding litigation. I think there might be a package that will protect some people from being sued. But I think the lawyers, there'll be a lot of lawyers that sue a lot of people for a lot of things. Right,
right. Interesting. You brought kind of the legislation component into effect, because I've also I caught something yesterday about prime. I guess in Britain. They're reevaluating their, I guess, insolvency laws, which I guess equate to our bankruptcy laws. As it relates to, as we come out of this, they're wanting to protect businesses in hopes that they can start back up without being drawn back down. Or maybe just brought into play, and it was $100, and I'm not going to take that because I think you're right. But are you betting on any other changes in legislation as it relates to this crisis?
This is usually
your opportunity.
This is usually where Phil lets me talk.
Yeah.
I think that if you were to ask me to look in the future, I think that we're gonna look at the role of government. Let me just say, we will look to the role of government significantly different a year from now than we do right now. If you looked at March 1st and you look at March 1st next year, the role of government in our lives, in terms of beneficially, in terms of privacy, in terms of what government does to help the vast majority of the population, the role of government a year from now will be significantly greater than it was on March the 1st of this year, when nobody could ever have foreseen that the government would step in and ever pass legislation that it did in a bipartisan way for the most part. Right. And I think that will it will very much change the system when you've got legislation that's already been passed that allows people to tap into their 401ks and their IRAs. I think it's a wholesale change in the way that we look at the government's role in our life, and I think that there will be no going back, particularly to that, because this was bipartisan, and I think there'll be more of that.
I think let me help you out on this, Abe. I think one of my guesses is that there's going to be a lot of rejection of claims under business interruption or rent interruption insurance policies, and that will be a hotly litigated topic, and it's possible that could end up with some kind of legislative change to say a global health pandemic is the kind of event that must be covered under those policies. I think many of those policies are going to be found not to cover that right now. It may depend upon whether a major disaster has been declared in the area where you are or not, as to whether you can shoehorn yourself in under a business interruption or rent interruption insurance policy. Those policies have timing requirements for making a claim. So if you sit on it and don't timely file, you may lose your right to file for a claim. So that's another area that's going to get focused on. As far as bankruptcy is concerned, Greg, I think we've heard a few rumblings about that, but I don't think anything specific yet. Greg, you also mentioned the sort of moratorium on evictions. So just quickly on that, I mean, that's kind of like a stay of the death sentence, if you will.
Right. It's
so
going to happen.
A tenant that was going to get evicted before all this hit. The eviction had been filed in March. Didn't have anything to do with.
It's their lucky day.
With COVID-19. That has been now held. It's all frozen in place. Nobody has to do anything. Clock's not ticking. Once that is lifted, that clock will start ticking again. And I don't think the tenant who was going to get kicked out in March because his business was failing and he wasn't paying rent is going to be in a better position in May to pay the rent. So it may buy him a little time, but I think at the end of the day, those same people are going to get evicted. Now, landlords that can't start the eviction process for failure to pay in April. If a tenant didn't pay right now, they can't do anything about it. But that doesn't mean they can't do it in May or June when the moratorium gets lifted.
Yeah, Greg, I think on the insurance side, the market that we've got across all different products, there's a huge amount of product that is owned by big institutional groups, oftentimes with global capital today. And I think that those folks are going to spend a lot of time talking with their insurance companies. And in those cases, those policies are, I think, one can imagine, will be rewritten so that viruses and pandemics and things like that will be covered under rent loss insurance, which by and large today, they are not covered under rent loss insurance. And I think that what will happen predictably is that coverage will be better for the landlords, and that cost will ultimately be completely passed on to the tenants. And that the tenants then, who most insurance clauses in almost any category of leases are not capped. So the landlord, if the landlord decides they're going to have another 25 cents or 50 cents or whatever it's going to be of charge that's going to protect the landlord and the tenant, that cost is going to have to be incurred by someone somewhere. And it probably will be bought by the landlord and passed through to the tenant. I think it's unreasonable to think that smaller tenants are going to change their business interruption policy to add a provision that takes care of a stated claim item like a virus. I think that you can assume that the tenants do not have that level of sophistication to buy the insurance, and they're buying their insurance already at the lowest cost they probably can. So I think that's going to be a landlord resolved issue, I believe.
That'll make it easier, because in the past, when we always try to argue payment of rent into the force majeure or business interruption clause, usually the attorney on the landlord side tells us that that needs to be covered by the tenant's business interruption insurance, and that we need to be sure that it's there. And quite frankly, up until this pandemic, it pretty much covered everything that normally we would have thought had happened. So you're dead on, and I love to hear that, if it eases the lease process where, it does fall back on the landlord, that expense obviously will get passed through to the tenant, but it's got to be covered somewhere. And I'm glad
it's going to be covered. It'll be covered by the landlord, because the landlord is going to have the capacity to buy insurance for enormous portfolios, and so they'll be able to spread the cost of the insurance out over millions of square feet. It's just not it's not practical that the tenants will have the acumen to determine how to buy that insurance. I suppose the alternative, which is a bad alternative, is that there's a different clause that's stated in the lease that they're passing through a specific charge to the tenant, but I just don't see that at all.
I like your approach.
Well, I think there are a lot of leases that have the landlord's right to carry rent interruption insurance, and it's at least worthy of the question from the tenant: have you tried to make a claim under your rent insurance, rent interruption insurance? It may not be valid because of the specifics of the policy, but as a tenant, your position is, I'm paying for that. Well, I should get the benefit of it.
From talking to the insurance brokers, the only sorts of policies that likely carry coverage that would be related to a pandemic or a virus, you can assume would be things like the Olympics, where people are where the policy was negotiated line by line. There may be some other sporting events where that will be taken care of, but in the normal course of business, the big landlords pick anybody you want, but they simply are not negotiating for that sort of coverage for an unlimited variety of rent loss.
And same on the business interruption insurance. And actually, I think I may have read something that you guys put out that most business interruption insurance contains a pretty standard rider, and pandemics are excluded in it, which I found fascinating.
So that may be something that gets changed
right,
legislatively or otherwise, like Abe mentioned earlier. I want to also just say that this kind of time, what we're all facing, kind of reminds you of 9/11. It may even remind you of some other incidents in our lives, but it's the kind of time that people remember vividly. And I think people are going to remember how someone treated them. So as a landlord or a tenant, thinking about the landlord-tenant relationship, I think you just need to step back and, beyond the financial implications of your decision, think about the long-term implications of your decision. So if all the tenants get no relief from a given landlord and suffer through, I think they're going to remember that at the end of their term when they're thinking about whether they want to leave or move or relocate out of the building. So I just think you need to keep that in mind as well, on both sides of the negotiation. It's a relationship creation process or a relationship damaging process, one way or the other.
Over time, we may forget what someone may have said, but we always remember how it made us feel. So I think you're dead on, Phil. Gentlemen, we've covered a lot of topics today, from insurance to force majeure, to probably the most practical advice in this call, which is the communication and relationship is the utmost importance in this time of crisis. I want to thank you both for joining for this call, and for AGG being there for the Commercial Board of Realtors in every possible way every time we make a turn, particularly in a crisis moment like this. And I want to invite the audience to please go to the AGG website and review the COVID-19 section within the website. And I want also everybody to know that we will, at the Commercial Board, be conducting another presentation with the AGG team as it relates to the CARES Act and how it can assist potentially each and every one of our practitioners.
Greg, thank you so much to you and to the board. We're here for all of our friends in this community. So thank you so much for the time.
Thanks,
gentlemen.
You.